Hello, everyone. Hello, testing. Sorry, too much. Um, First of all, good afternoon. I would like to thank you all for your presence here at the Harvard Law Brazilian Association Legal Symposium. I speak on behalf of the organization when I say that we are thrilled to have you here. Before I introduce our esteemed panelists, I would like to kick us off with some considerations on the subject matter of that which is going to be the last talk of the day. It is a brave new world we find ourselves in. Globalization has made human beings capable of more interaction than we ever thought possible, enabling a somewhat overwhelming pace of progress. This translates into every aspect of our professional, personal, and social lives, which are irreversibly subject to more technological and legal advancements than we can make sense of. Keeping up is a tough job, at least for me. In the age of internet, social media, capital markets, and global corporations, national economies have become significantly intertwined, and economic agents have extended their presence far beyond the boundary lines of their countries of origin. Cross-border disputes arising out of these newly founded international relations became part of the landscape of the 21st century, and the nature of the world in which they arose demanded new, cost-effective, time-efficient ways of handling the strife of ordinary business. Therefore, some of the questions that are posed to the modern practitioner of law that is inserted in this reality of the 21st century are, how do we go about designing these new ways of solving conflicts? What would an efficient dispute resolution system look like? How do we equate the incentives to prevent these new systems from backsliding into costly and time-consuming proceedings? And most importantly, what are the trends of today and what challenges lie beyond tomorrow? Helping us understand and navigate these issues, we have today Professor Rachel Viscomi and Paulo Nasse, whose impressive curriculums I will attempt to summarize in just a bit more than a few words. Professor Rachel Viscomi is the director of the Harvard Negotiation and Mediation Clinic here at the law school, where she also teaches courses such as dispute systems design, advanced negotiation, and lawyer as a facilitator. Before coming to Harvard Law School, she worked as a principal in the corporate education practice of Vantage Partners, a Boston-based consulting firm that helps clients achieve business results by transforming the way they negotiate and manage their key relationships. Our other panelist, Paulo Nasse, is a Brazilian attorney with experience in international practice in both New York and London, and a partner at Miguel Neto Advogados. He obtained his JD from PUC São Paulo, where he later pursued a master's degree in private law and a doctoral degree in procedural law. Paulo Nasse also holds a specialization in bankruptcy law from New York University and a master's degree in international commercial law with emphasis in international arbitration from the London School of Economics. A last reminder before we begin, we will be using the last 30 minutes of the presentation to take questions, so please do use the slide.do app to send the panelists questions. And without further ado, I will now pass it on to Professor Rachel to kick us off.
Hi, everyone. It is lovely to be here with you today, and I admire you for sticking all the way through to the end of the day. I can imagine that that was not easy for everyone. I'm so excited to be here and to be part of this panel, and really honored to be co-presenting, and am really looking forward to sharing just some preliminary thoughts about dispute systems design, which is one of the things that I spend a lot of time thinking about, to see whether it is useful at all as you are thinking about some of the disputes in which you are engaged and thinking about managing. So I'm going to do a bit of a whirlwind overview, and hopefully it'll be a little useful. So when we think about dispute systems design, what we're really talking about is trying to look fairly comprehensively at a set of disputes or conflicts and figure out, is there a more effective way that we could be managing them? right? Is there a way for us to think not just about the one-on-one situation that might be coming up, but about the whole stream of disputes? And often what we find when we start to broaden our lens a bit is that there might be, within any given context, some disputes that we are handling reasonably well, others that we could be handling more effectively, more efficiently, in a more cost-effective manner, in a more satisfactory manner for the parties. And then some others that actually may not really be coming up to the surface at all because the parties don't have a lot of faith that they will be engaged effectively. So what we're trying to figure out is pretty holistically, what's going on? Is there a way for us to do it better? And let me actually go back and say one thing. You'll notice I'm talking about dispute systems design. My slide is talking about conflicts. Let me say, some people believe that there is a really important and substantive distinction between disputes and conflicts. I'm not one of those people. Which is helpful because the people who believe it really strongly believe it in different directions. So some people believe that a dispute is a fairly minor matter and a conflict is something that is enduring and intractable, and that you're not going to be able to sit down and problem solve around. Others believe the opposite. So for our purposes today, for my purposes, I'll use the words really interchangeably. A definitional distinction that I do care about and I think is relevant for our purposes today is the distinction between cases and disputes. So I know for many of you, your law school days are behind you, but as you stretch back, for those of you for whom that's relevant, for the most part in law school, and certainly here at this law school, a lot of what we do when we talk about cases is engage in a process of specificity and kind of really narrowing down and carving things away, right? So when we look at a traditional case in law school, we're usually looking at only the parties who are directly involved in whatever the subject at issue is. And so we often get a set of facts in which we are disregarding many of them because they're not legally relevant, right? So if we're trying to make a determination around, whether an assault has been committed, we want to identify what are the specific elements of the crime. Do any of these facts give us information about the intentionality of the behavior or the perception of the behavior? And if not, we don't particularly care for purposes of most cases. Very different when we are talking about disputes in this context. What we are doing is actually casting a much, much broader net, right, as we think about dispute systems design. And we're doing that intentionally, right? We're trying to think about conflict as a source of value. So not something that we're trying to avoid, but something that's really an opportunity for us to think creatively about how we might bring to light topics about which people have different views, situations in which people might feel aggrieved in some way or another, and see if there's a better way for us to engage and problem solve around them. So, for example, we're actually often going to take our starting point and we're going to look more broadly. We're going to say, are there other folks who might care about this? Are there other stakeholders who might have an interest that maybe we haven't spoken to? Are there related conflicts or different topics or issues that we should really be taking into account? So that's a pretty important thing to think about as we go in. And you'll notice, so this is sort of a broad pyramid representing, in a very informal and impressionistic way, the kinds of cases or the kinds of conflicts that come up and the ways that people have of dealing with them, right? So the actual conflicts that we engage with in the legal system and even more narrowly in law school really sit at the very top of that pyramid. So we are focused usually in law school on cases that actually go all the way up to the highest courts in the land, and cases in which there is a written decision and one that feels actually particularly important and relevant for purposes of looking to other disputes. And that's a really small subset of the types of things of the types of disputes that are arising and the different ways in which people manage them, right? So you'll notice at the very bottom of our pyramid, there are quite a few disputes or conflicts that come up with that that never make their way into the legal system at all because people are inclined to simply walk away, right? Or they're inclined to avoid it in one way or another, right? They might decide it's not worth it. They might decide that they can manage it on their own in some way, but it's not something that sort of rises to a legal level. So as we start to think about ways in which we can be more thoughtful and more creative about the ways in which we address disputes, there are a whole series of continua that can help us think about the kinds of processes we can use, right? So looking beyond, obviously, litigation, we're thinking about kind of what are other processes that we have at our disposal. And this, this slide and the next slide, I really wanted simply to give you a sense of the range, right? And the level of intentionality that we can have when we start to think about mapping disputes and processes together, and particularly mapping processes in a particular system. So I realize that the visual is a little light, so I don't know if folks can read it, but you can see at the top, there's private versus public. So, right, that's something that comes up often, and something certainly that's come up a lot in the U.S. recently around settlements related to sexual harassment, situations in which, for any number of reasons, parties might be inclined to have a private settlement, might be inclined to keep the facts and the disposition of a particular matter to themselves. And there might be some costs that relate to that, depending on the circumstance. So we want to be pretty careful in thinking about when does it make sense for us to have things in the public eye? When does it make sense for things to be open and transparent? And when is it, in fact, preferable for parties to be able to make decisions that keep things under wraps? Consensual, voluntary, compelled, mandatory. So this is something that comes up often in the case of mediation, for example, and maybe something that you guys have already been thinking about today. I didn't catch all of the previous panel, unfortunately. But when you're thinking about a process and a process that might be helpful to disputants, even if you are persuaded that it's very, could provide a lot of value, do you insist that people participate in it? Do you offer it as a process that if it feels helpful to them, they can choose to participate in? So this is, sort of a high view of some of the different the spectra across which you can make some decisions, right? Of course, advisory and binding, if we're thinking about arbitration, do we want to actually give people a decision that is the final decision, or do we want to give people a sense of, here's how this case might come out, and does that impact a settlement that you're comfortable reaching on your own, right? So different ways of thinking about the different processes at our disposal. Again, kind of more of the same, trying to really reflect on where are the opportunities that we have to make choices, and what choices make sense based on the context. And the context is a really key part of what we think about, and we'll get to that in a moment. So as we think about what a system might look like, we want to be thinking about how much ownership how much autonomy, how much decision-making power do we want the parties to have? How much do we want to sort of deliver an answer to them? How binding do we want it to be? So you might think about sort of a negotiation on one side, litigation on another side, and kind of an array in the middle of different processes. This is not a, sort of magic written in stone visual, but it's to give you some sense of the ways in which we might be flexible as we think about these things. And as we think about sort of how do we want to go about designing a system, these are a couple of the preliminary questions that we want to start to engage, right? So who's actually involved? What are the issues? Yeah, so stakeholders, when we think about stakeholders, we're talking about really anybody who might have an interest in whatever the dispute is. So somebody where a decision might have an impact on them, folks who might be members of the community in which something is happening, folks who might be able to offer input, oftentimes expert stakeholders. Great. So just to, partly for comic relief, but also to really kind of put a point on this distinction, when we think about ADR, we're talking about many different processes, right? Many different ways of engaging conflict. The same, in the way that we think about that, if you imagine that you are feeling depressed or your spouse, someone you care about is feeling depressed, there are a bunch of ways you might treat that, right? Or you might think about trying to engage with that depression, right? So you might take medication, you might go see a counselor, you might, go running, get some exercise, get your endorphins up, you might meditate. All those are individual processes. What a dispute systems designer does is act as the doctor in this scenario, right? And give you a prescription or a sense, a diagnosis about what's going on and what combination of processes might be helpful to you, right? And in every situation, they're not going to give you the same answer. Same thing is true for us. So really what we want to be doing is looking at the individual processes. So, kind of the big ones that we tend to think about are litigation, negotiation, mediation, arbitration. And these each do different things, right? So some people, Lon Fuller, for example, had real thoughts about the fact his view was that each of these processes had sort of a different morality, and that they were suitable for different disputes in part because they had sort of a different ethical valence to them. You may or may not buy that, but it's undoubtedly true that depending on what the circumstances are, these different processes might feel more or less appropriate. If, for example, you have a dispute in which the relationship feels critically important, litigation is probably not your best approach, right? Mediation might be much more likely to produce a satisfactory outcome. In a situation where, it's really imperative that there be a clear and unequivocal decision in relatively short order, you might be more inclined to look to arbitration, for example. So really trying to understand what the interests are and how to tailor to them. So these are sort of our key and basic processes, but they're only a small subset, right? There are a number of other processes. This is just by way of example, right? Different ways that folks get creative about incorporating different processes into a dispute system. So you might have, situations in which you have variations or hybrid processes of those basic processes that we looked at a moment ago. Key concepts when we think about what a system looks like is thinking about what are the different approaches that we might use, right? So there's a distinction, and it was sort of initially drawn out by Uri, Brett, and Goldberg in a book called Getting Disputes Resolved, quite a number of years ago now, which sort of talks specifically about what is the difference and when might we use a power-based form of resolution versus an interest-based or a rights-based form of resolution. So interests, we're really thinking about kind of what's important to the parties, how do we structure something that makes sense for us. Rights-based, we're really looking to, are there criteria? Is there some sense of fairness or third-party legitimacy that we might look to help make a decision? Or power, right? Is one of us able to simply impose an outcome on the other, whether that might be through a strike, whether that might be through, grounding our child, whatever it might be. So when we think about those concepts in the context of dispute systems design, they kind of fit within each other and nest in a certain way, right? We're really thinking about in the way that we sometimes talk about negotiating in the shadow of the law and the ways in which an agreement that we reach might be limited or constrained by or informed more by what it is that we think would happen in a court of law. The same can be true as we think a bit about what systems, what processes make sense in a given system. Uri, Brett, and Goldberg really talk about thinking about what does a healthy system look like. And the idea is that for many more systems than we might like, they look like this left-hand system, right, where power is more the default than the exception. And in order for us to have a really healthy and functioning system, we actually would rather shift to the right-hand side. Right, we'd rather be able to resolve as many disputes as we can in a way that is premised on an understanding of interests and giving the parties some say and some ability to reach an agreement that meets their own needs, and have progressively fewer that rely on rights and power. So kind of broad sense, as we think about what are the actual steps of designing a dispute system, the first is design initiative, which is to say sometimes there are moments where an organization or a person or someone will come to you and say, hey, I heard you design a great dispute system. Can you come help me out? Those tend to be fairly limited, right? So often when we're thinking about, is there a situation where we see a need, right? Is there a place where we feel like there might be a more effective or more creative way of engaging this set of disputes? Is there a way for me to suggest that or to get involved or to suggest that someone else start to look at this issue and build some consensus around it? So that in and of itself can be a pretty powerful concept, right? The notion that we are sort of looking around and making assessments as to what we could be doing better in the context in which we're engaging with others around disputes. The second, which is really important, is around assessment. The goal of assessment, right, we might love a particular process, right? So we might be real fans of mediation, really devoted to arbitration, quite passionate about restorative justice. What we don't do, or what we would counsel not to do, is to say, this is the perfect process for every dispute that comes along, right? Or this worked really well in this context, let's pick it up and drop it into this other context. What we want to do instead is understand what is true in this context, right? Who really cares about this situation? What's happening right now? So we start with our stakeholders and really trying to understand who is engaged, who's involved here, what are the conflicts, how are they currently handling them, and what does that mean for us as we think about moving forward and doing some design work. So it's this McDreamy, I thought, might be a little more accessible. So we want to start with stakeholders, right? And think about who actually has a stake in this conflict, right? So who might have expertise, who might really care both about the conflict that's happening, but also about potential solutions, right? Who are we likely to anger if we step on the wrong foot? So this is an example, which I include only because I think it shows you the complexity of what this can sometimes look like. This is an example of a stakeholder analysis or a stakeholder map, really, that was done with respect to some consensus building work related to a forest in the UK. And you can see that once you start to really expand your lens, you can end up with quite a significant number of parties who care, right, about the dispute, and who in some way might have a role either in really informing decisions that we might make about what a system might look like, or in helping, kind of implement or come up with a system. So it's not always this complex, but it can be. And we want to think about conflicts. What kinds of conflicts are coming up right now in this context? How often do they come up? In what way do they manifest? Do they show up? So in an organization, sometimes conflicts come up because people go to the human resources department and they say, hey, I'm really upset about this. Other conflicts come up because they come up and people leave, right? They say, I don't want to stay here. I don't want to engage this. And it's important for us to have a sense of what the real universe is and the impact it's having on people's behavior. And then to have a sense of what are we currently doing about them? When they come up, what is it that actually happens? So, does someone typically raise it, and are they told, here's the answer, go about your business? Does it come up and someone says, wow, that sounds really difficult, I'm so sorry, I hope it gets better? And then they go back and they try to work it out. Is there a particular process they go through? Do they need to bring a formal complaint against a coworker, for example? And if so, what's the impact of that? How eager are people to use that system? How well is it working? And so forth. And then based on our analysis, we start to think about how we move forward. So I think what I'll do is pause there. But what I would say is that this part, apologies if I've belabored it a little bit, the assessment is a really, really critical part of the design, which is to say we want to make sure we have a detailed understanding of this specific circumstance before we start thinking about what a system might look like. And when we do start thinking about what a system might look like, we want to be pretty creative. And sometimes it might be the case that one process is the answer, but often there might be an interrelationship and a sequencing of processes, right? We might try to sort of start with having people talk to each other without maybe the assistance of a third party. And if that doesn't go well, we might choose to have them have the opportunity to collectively request a mediator, work with a mediator. If they're not able to come up with an agreement that makes sense, we might decide to give them an opportunity to prepare their case and to go in front of an arbitrator, but potentially in a non-binding way with what we think of as a loop back to interest, so an opportunity for them to sort of have a sense of how someone might come out, but then potentially have another opportunity to reach an agreement on their own before it moves forward. In another circumstance, that process, that whole system wouldn't make sense, right? Because if our driving goal were sort of speed or efficiency, we might have less of an emphasis on autonomy and on interests. So it's going to vary. That's my headline would be, it depends. But I think it's actually really critical as we think about what it looks like to really engage in this process. So I think I'm gonna pause there so as not to so as not to take up too much time. And I'm really excited to hear what Paolo has to say.
Posso usar esse microfone pequeno aqui? Posso usar esse microfone? Ele está sem bateria. Ah, tá. Good afternoon, ladies and gentlemen. I would like to express my praise and my honor to be in this event. I'm really delightful to speak alongside well-regarded and very well-respected figures of the law scene. Even though this increases my responsibility of delivering an interesting talk, but still I prefer to feel this honor of being alongside these well-respected professionals. I would also like to thank very much the organization of the event, the Federal Judges Association and the Brazilian Association at the Harvard University. And I do this addressing my sincere thankfulness to Mrs. Isabella Ferrari, without whom, without her tireless efforts, this would not be necessary. She's not in the room, but Eric for sure is going to deliver my thanks to her. My talk will address some challenges currently faced in international arbitration as a method to resolve disputes. So the main question I present to inspire the discussion today is how arbitration practitioners may drive progress in the resolution of international commercial disputes. How did I structure my presentation? So firstly, I'm going to give an overall view of some key characteristics of international arbitration. Secondly, I will address three particular issues which I understand that deserve our efforts and creativity to enhance the effectiveness of arbitration. This, of course, will help us to achieve progress in this field of dispute resolution. So what is the concept of international arbitration? I may say that this is not univocal. Okay, for instance, the UNCITRAL rules, the United Nations Commission on International Trade, brings on Article 1st a handful of situations where an arbitration will be considered international. So, for example, when parties are arbitrating in a place where they are not incorporated. So we have quite a few situations there in the UNCITRAL rules defining what an international arbitration is. What does it matter under Brazilian law? Nothing. Under Brazilian standards, what matters is the place where the award has been rendered. It doesn't matter the law applicable to the case. It doesn't matter the nationality of the parties, neither the arbitrators. Under Brazilian standards, a case will be considered a foreign case and therefore will need to be ratified by the Superior Court of Justice if the award is rendered outside the Brazilian territory. For the purposes of this presentation, the concept of international arbitration, from my perspective, will embrace the idea of resolving a dispute with any cross-border aspect that may influence the parties to decide for this alternative dispute resolution method, instead of going to the national courts. So, for example, we may have situations where parties are arbitrating a case outside their home countries, or selecting a different language, or seeking a future enforcement in a place which is not the place of arbitration. So I may have an award rendered in Brazil, and in the future, I want to seek assets or to try to find assets with this arbitration award, enforcing it somewhere else, like in the United States or in the United Kingdom. So I prefer to say that international arbitration, especially for the purposes of my presentation, comprehends disputes in which there is a cross-border component as a fostering element for the parties to decide not to seek protection of the national courts. What is the relevance of arbitration in solving disputes, especially in the international scenario? Well, I see arbitration as a key mechanism to enhance the effectiveness of dispute resolution. And why? Because arbitration, firstly, tends to be less formal. And my fellows from Jurídico Sem Gravata will like this affirmation very much, because it tends, of course, to be less formal, and therefore there is a trend of being slightly more effective. But why do parties go to an arbitration, or why do parties pursue the resolution of the dispute in an international arbitration? What are the goals of the parties? The first goal, I would say, is to seek a final and binding decision. So, as Rachel explained to us, there are certain methods whereby we find a recommendation, or we find settlement among the parties. But sometimes this settlement is not possible for any reasons for many reasons that we may bring here. Eric Navarro, for example, and Professor Luciano Tim always say that the lack of balance of information knowledge between the parties is something that go against the possibility of a settlement. So the first thing that parties seek is a final and binding decision. Parties seek to resolve the matter at stake without having a long battle. And especially because litigation is part of the business, litigation is part of the company's issues in the daily basis, but it cannot be a goal on its own. As we could see this afternoon in the former panel, just before our panel, there are some companies that go to the judiciary to make it the way they do business. For example, we have some kind of mass litigation, mass banking litigation, whereby the banks go to the courts to stay with the money of the parties, the money of the customers, the more they can, because at the end of the day, or in the end of the 10-year term of the lawsuit, they will pay only 1% of interest per month, whereas they lend this money for 5% a month or 6% a month. So this is a way of doing business for some specific companies. However, when we get to a conflict which is very much related to the core business of the company, it is more likely that the parties go to an arbitration or to a deep litigation in order to take the problem out of the way. Why? Because sometimes having this problem harms the image of the company, the business of the company, and in the end of the day, not all lawsuits are composed by parties that will not engage in future negotiations or not engage in future business. It is very common in high complex litigation that these parties involved in a conflict will keep fighting, will keep having a battle for some time, and this will harm their relationships, and they need to go back to the table to do business. So this is something that parties bear in mind when they go to arbitration, because they seek a final and binding resolution of the question, but in a straightforward manner with a business-oriented way of deciding the case. What else people seek, what else parties seek in an arbitration? I would say, in international arbitration, enforceability of the award in different places. And why is this possible? This is due to the New York Convention. The New York Convention on Recognition and Enforcement of International Awards allow parties to have an award in a certain country and enforce this award in another signatory country. So these allow the parties to seek assets somewhere else, and this is due to the possibility opened by the New York Convention. For example, if an award is rendered in Brazil and the assets of the debtor are in the United Kingdom, it may be well enforced in the United Kingdom or United States or somewhere else. Brazil is a signatory of the convention since 2002, 1 year after Iran, and the same year as Zambia. The convention is 1958 convention, and this, I would say, late comprehension of the convention and the adoption of the convention in the Brazilian law system was due to the necessity of incorporating the culture of not going to the courts, which is something that is growing substantially in the country for the past years. I would emphasize as well the expertise of the arbitrators. We know that court judges are very well-prepared people, but sometimes this expertise of the arbitrators go beyond the law knowledge. It goes towards some linguistic abilities to have the arbitration in many languages, or business knowledge that sometimes you may find in arbitration in the international scenario. And especially because as the arbitrators are remunerated to analyze a certain case or a certain bunch of cases, it's much more likely that the arbitrators will dedicate more time because they don't have 5,000, 10,000 lawsuits in front of them. So this is the main idea when I talk about expertise. Of course, we also go to arbitration to avoid certain ills that may arise out of court litigation, such as long-lasting procedures, such as the difficulties to reach res judicata. It's a very high challenge, especially for us in Brazil, to reach res judicata. Not only due to the 4 instances that Eric Navarro made a reference today, but because among these instances we have quite a few appeals that are not only 4, so we may litigate for many years, and this goes very much against the goal of having a final and binding resolution for the case. Of course, confidentiality and privacy to protect some secrecies of the business scenario, and party autonomy and flexibility to choose the rules. And here come the 3 challenges that I mentioned at the very beginning of my presentation. And I will address now in the second part of my presentation these 3 challenges that are very important for us to think about in the international arbitration scenario. What is the first challenge to be dealt with in pursuing this progress and dispute resolution in an international scenario? The first one is the influence of multiple systems in international arbitration, multiple law systems, legal systems, in order to have an international arbitration. There is a very complex interactions of laws that shall be well known by the parties before engaging in an international arbitration. And the parties have to simplify this, otherwise this is going to be a nightmare for the parties in not having clearness in knowing what are the laws applicable. I would emphasize at least 4 groups of laws, systems of laws, applicable at the same time to an international arbitration. The first one, the first system, would be the governing law, the law applicable to the underlying dispute, the law based on which the merits of the case will be decided. In this case, the law shall be familiar for the parties. This is because the rules will guide the conduct of the parties and regulate the consequences of their contractual behavior throughout the relationship. In the end, what is the purpose of choosing a law? What is the purpose of choosing a governing law for a contract and for a dispute? The main goal is to know in advance the set of rules to govern that relationship and know the exact consequences that the acts and omissions of the parties will generate in that long-lasting relationship. So sometimes choosing a neutral law becomes a nightmare for the parties, becomes a very, or drags the parties for a very sensitive situation. Because sometimes parties to a contract are not familiar with that law that they had chosen for that specific contract. There is a Rio case, and the players, I will suppress the name for confidentiality, but it's a case in which, or a contract in which the parties chose a New York law to govern their acts, obligations, and duties. This contract was between a Brazilian company and a French company, and to be performed in Brazil. They would develop unmanned vehicles in the country to sell to the a specific authority in Brazil. Well, the parties performed the contract in the country. And then, 3 years later, they had a huge dispute on the termination of the contract and on the grounds for termination of that 5-year term contract. What happens here is that the employees of the companies behaved bearing in mind the Brazilian and the French law. Why? Because they were either Brazilians or French people. And they did not drive their conducts based on the law of the contract. So this, in the end of the day, brought the parties to a very sensitive situation. Why? Because they were thinking about the law of the conflict in the contract, but they were not bearing in mind that the law that would be chosen for the parties to behave would be the law that would govern the behaviors of the parties. And then in the end of the day, choosing a neutral law may bring you to a very sensitive situation. So the takeout on governing law would be that this is not the law for the conflict only. It's the law that will drive the behavior of the parties. So here's the first law, governing law. The second one is the procedural law, the lex arbitrii. And it may be completely different from the governing law chosen by the parties. Why? Because ordinarily speaking, the law of the procedure, or the procedural law, the lex arbitrii, will be the law of the seat of arbitration, roughly speaking, the place of the arbitration. And this law of the place of the arbitration will guide several issues related to the dispute that the parties are bringing to that specific country. So an arbitration in Brazil may be governed by New York law, but if the arbitration is in Brazil, the law of the seat of arbitration applies. So when I think about the law of the seat of arbitration, there are some concerns that may be brought to the table. The first one is the requisites for the arbitration clause to be valid. The second one would be the limitations on party autonomy. So, for example, in Brazil, we have a situation where the law says that if you are before a adhesion contract, that is, a contract to which one of the parties had no opportunity to discuss the clauses, not a consumer contract, it's a civil contract, but to which one of the parties had no opportunity to discuss. In that case, specifically, the law says that an express acknowledgement of the arbitration clause is necessary for the arbitration clause to be valid and effective. The arbitration clause shall be in bold. The arbitration clause shall have a signature on the side for the party adhering to that contract to acknowledge that the party really saw that clause and saw that the party would not be allowed to pursue their rights before the courts. So even if the law of the contract is English law, the law of the seat will apply. Excuse me, let me get some water here. So why is the procedural law important as well? Because it's going to regulate the relationship between the arbitration and the courts of that country. So what should I think about before choosing a seat of arbitration? Am I before a courageous court system or judiciary system that may give me an injunction or a conservatory measure if I need? If so, it's a good place for serve as a seat of arbitration. If it's not, then I need to go somewhere else, because at a certain point, I may need the assistance of the courts for conservatory measures and for the annulment of the future award. So what are the grounds for annulment of a arbitration award? It depends on the law of the seat of arbitration. So this is why choosing the law of the seat of arbitration is also very important, and it's a complex interaction among systems of law. Of course, as well, the public policies and the fundamental values of the state will play a key role, as well as arbitrability. That is, whether that specific contract, that specific matter is suitable for an arbitration instead of going to court litigation. The third system of law is the New York Convention. So if I am in international arbitration, I need to pay attention to the governing law, to the law of the seat, that is the procedural law, the New York Convention. Why? Because if I am in an arbitration procedure where one of the parties is incorporated somewhere else, the assets are very likely to be somewhere else. So if I don't pay attention to the requirements of the New York Convention to enforce this award somewhere else, I will have an award in the future that will not be enforceable where the assets are. And the fourth set of rules would be soft law. Soft law, when I say soft law, I talk about, for example, the International Bar Association rules on taking evidence. So how am I going to get evidence in these records? Am I going for disclosure, full disclosure, limited disclosure, or parties will use the documents that are in their possession without requesting disclosure? This is going to be regulated by the parties. And this is going to be another set of rules that parties need to pay attention to when interacting these systems. So what are the takeouts to drive progress in this first concern that I have, in this first issue in international arbitration? As to governing law, to choose a law suitable and familiar for the parties to drive the behavior and not only the rules of conflict. As to the lex arbitri, as to the procedural law, the law of the seat of arbitration, the seat shall be a country that works well alongside arbitration. And I have to say that Brazilian courts have been very supportive to arbitration throughout the past 20 years. I would say that the judiciary power has been a key element for the arbitration to be successful in Brazil, because it has been very courageous in assisting arbitration without being so inclined to conserve jurisdiction in certain cases for itself. Also, I would say that when I choose the law of the seat or the seat of arbitration, I may need to make this question to myself. Do I want a judicial review? In which grounds? Do I want review on the merits? Because Brazil does not allow review on the merits. But the United Kingdom, in Article 69 of the English Arbitration Act, allows an appeal on a point of law. What do I want? If I want an appeal, I need to go to England. If I don't want it, I can go to Brazil. So this would be one takeout on this. As to the New York Convention, to see the requirements for future enforcement, and as to soft law, we shall choose, especially in evidence gathering, a law that is suitable considering the background of the parties. Rules on gathering evidence are very sensitive. Disclosure or discovery, what else you are, sometimes may be a nightmare and bloody expensive for the parties in the procedure. And these need to be seen under an idea of economic effectiveness of the procedure. The second concern, the second issue that I would bring today in order to think about a more effective international arbitration scenario is the overcome of cultural barriers, especially regarding the selection of arbitrators. It is very common in international arbitrations that parties fail to agree in advance the characteristics of the president of the future arbitral tribunal or the single arbitrator that will rule upon the case in the future. In many cases, parties define that the presiding arbitrator or the sole arbitrator will not have the same nationality of one of the parties. This is what people sometimes do in contracts, but without defining the characteristics of this president. The characteristics of this sole arbitrator when the arbitral panel will have a single arbitrator. The ICC rules on arbitration also goes towards the same idea. In Article 13.5, it says that the sole arbitrator or the president of the arbitral tribunal shall be of a nationality other than those of the parties. Clearly, there is a fear of an unconscious bias of the arbitrators in judging in favor of a national of that specific country or its own country. However, it seems to me that these rules on the nationality of the president or the sole arbitrator are inefficient for the purposes of suppressing unconscious bias. If we need to fear unconscious bias in the international scenario, we need to enhance the standards of trustfulness in the arbitration by other manners. This is not a World Cup match in which I put a Russian referee to blow the whistle in a match between Japan and Argentina. Why do they do this in football? Because it needs to appear neutral. Why? Because football is a matter of passion, and the rules are standardized. So I can put a referee from somewhere else to arbitrate a match between Argentina and Japan. However, personal passions, from my perspective, shall be out of the table when we talk about arbitrating a dispute. When the person is arbitrating a dispute, personal passions shall be out of the table. And in the end of the day, the laws in Japan and the laws in Argentina are completely different. So there is no point to have a person from somewhere else to arbitrate in a dispute like this. In this particular sense, I would say that the disclosure of potential conflicts of interest by the arbitrator is much more important than paying attention to the nationality of the presiding arbitrator. As an arbitration counsel, I'm much more interested in knowing the relationships of the arbitrators with the parties instead of knowing who is this guy coming from or where does he take vacation. Nationality shall only be at stake in the international arbitration scenario when there is a sound concern on the impartiality of the arbitrator. Being familiar with a certain jurisdiction or a certain system is not the same of being educated in that specific system. This is a typical catch-22. Why this is a specific catch-22? Because I escape from one danger in the direction of another danger. So escaping from a potential unconscious bias deriving from the nationality or allowing an unfamiliar arbitrator to rule upon the case. Is it sufficient for a given arbitrator to be able to read the statutes of a certain country? In Brazil, for example, reading the statutes is not sufficient and not that simple. In Brazil, the interpretation of statutes is complemented by the case law and the precedents and the binding precedents. So reading the statutes is not sufficient most of the times. Economic analysis shall be performed to avoid replacing one specific handicap for another handicap. It is preferable to have an arbitrator that knows the governing law very well and has a deep knowledge on the place where the commercial relationship took place. It is better to have a knowledgeable person with time to dedicate to the case instead of having a globetrotter who will not add much. Of course, the bills will come very high, but to the arbitration, nothing will be added in a significant manner. was my second concern, my second issue for us to think about. The third and final one, the third challenge towards progress is the stability of the system and mainly the interpretation of the law. Stability of the interpretation of the law. And I will mention the Brazilian case. Arbitration shall not be a supranational method of resolution of disputes. This is because the governing law is normally connected to a certain system, to a certain jurisdiction. Unless the parties set a tailor-made set of rules to govern commercial relationship and the potential dispute, the legal system of a certain jurisdiction will apply. So how to avoid a discretionary decision upon a case deriving from an unconventional and unpredictable interpretation of the statutes? My answer is enhancing the power of court precedents, enhancing the power of the interpretation given to the statutes. The meanings shall be consistent. Let's take the case of the statute of limitation, prescrição, under the Civil Code. After 15 years, the Superior Court of Justice has not defined in a definitive fashion whether tort, responsabilidade aquiliana, is subject to a 3-year or a 10-year limitation period. It's been 15 years already. Why? Because every justice that comes to the bench read the sentence civil compensation, reparação civil, written in Article 206 of the Civil Code differently. So differently from common law countries, based on the common sense and in the progressive construction of the law, Brazil is a civil law system, a civil law-based system, and the statutes have always played a key role in the system. However, from my perspective, the free interpretation of statutes without interpretation benchmarks and without interpretation restrictions may open room for the use of equity without express consent of the parties. Those who understand that a stable interpretation of statutes shall not be binding are taking a placebo. Why? Because in this situation, parties are pretending that law is being applicable, when in truth, equity, sense of justice, is being applicable to the case. Why these practitioners who advocate in favor of non-binding precedents avoid express authorization for the arbitrators to rule based on equity? Because equity is much less predictable than the law. Sense of justice vary from person to person and is a potential room for injustice and abuses. So courts shall enhance the interpretation stability without bearing in mind who is the defendant and who is the claimant. We need foreseeability in the application of the law. How can I know the results of my conduct if the statutes are read differently depending on the situation that appears before a judge or arbitrator? Also, in seeking stability, we need equal treatment because equivalent facts shall have equivalent solutions. If we achieve a consistent system of binding precedents of the statutes in the Brazilian courts, we may enhance the consistency of the application of the law, and we will enhance the trustfulness of the outcome of arbitration disputes in which Brazilian law is applicable to the merits. Professor Fábio Medina Osório yesterday mentioned Professor Alejandro Nieto from the Universidad Complutense de Madrid. This made me think of a passage of his book, El Desgobierno Judicial, when he says, Professor Alejandro Nieto from Madrid, sometimes the blindfold of the Lady Justice sounds like a sarcasm, because sometimes Lady Justice knows very well who are the parties before it. So to avoid this, we all need to have the law interpreted in a consistent manner, both for judges and arbitrators. Thank you.
Rachel, before we move into questions, I see you have a lot of notes. Do you want to maybe comment or something? Okay. So, even though we're approaching our time here, I think it's safe to say that we have generated a few questions, and I think most of them went for you, Rachel. So I'll ask you one, and then I'll ask you the other one.
Sure.
So I'll start with Rachel. The question is, can dispute resolution design be used ex post, that is, after the conflict issue arises? If so, what are some uses, and why is DRD preferred to the standard mode of resolution?
So, yeah, what I would say...
Sorry.
No, that's Cal. Grab this back. Don't mind if I do. So I would say yes. When we do design, we also do evaluation. The important thing to bear in mind is we're looking at a system. We're not looking at an individual dispute, right? So we might look at a system and say, how effective is this system? If, for example, in our clinic, we recently did a project that was evaluating a divorce mediation system that is used in a particular context, right? So ex post, an evaluation of a system that has been in place, looking at what's the experience of folks who go through this system? How does it work for them? What are the metrics they're using to assess it? In that case, the metrics they were using were heavily related to their success rate. So, 98% of divorces are settled, and they're settled within a very short time frame. Not the metric that we would use, right? So going back and saying, okay, well, what's the experience of folks who go through this process? To what extent do these agreements hold up? To what extent do people feel fairly treated? Do they feel like they understand the process? Do they feel like the interests that they have are actually coming to light? Or is someone basically, throwing them into a system that's designed to encourage a numerical haggle? So I would say the benefit of using a DSD lens is looking not just at an individual case, but looking holistically at the ways in which a set of disputes or conflicts are being engaged.
Thank you, Rachel, for the response. And next question, I'll be asking Paulo Nassa. It is, how influential are non-legal practices and arbitrators without legal formation in arbitration?
Very influential, I would say, especially because sometimes in arbitration we have very sensitive questions that demand a very deep knowledge in economics, a very deep knowledge in construction, engineering, etc. Where's the pitfall here? The pitfall here is that when you have a panel composed by non-lawyers or people that were not educated in law schools, there is a very sensitive situation because some concerns related to due process, some concerns related to the adoption of a certain legal system may be sometimes disregarded. This may well be disregarded by people educated in law as well, okay? But from my perspective, the sensitive point is that due process and other legal features that in the end of the day will be decided or will be decisive for the decision sometimes may be neglected by the parties or the arbitrators. So in response to your question, very influential, but I see a good decision, a very well-drafted decision when we have people educated in law in the panel, but assisted by very well-regarded professionals in certain fields such as construction, such as engineering, or economics, or all other fields that may be at stake in an international arbitration.
Thank you, Paulo, for the response. And with that, we're going to call an end to the panel and call an end to the day for our conference. Thank you.